Our next case is Jumaa State versus Prime Healthcare Services. This is a 20-minute grant. Good morning.
Morning. May it please the court, Michael Cook, on behalf of defendants, appellants, I do plan to reserve 3 minutes for rebuttal. Wrongful death claims are entirely statutory. They involve very complicated public policy choices, which I think are nicely set out in some of the amicus briefs that you received, in particular from Corwell, McLaren, and University of Michigan. Legislatures can choose how to compensate. They can choose to compensate from the decedent's perspective, survival acts. They can choose to compensate from the family and dependents perspective, death acts. They can also combine those two, which is what Michigan's done. When legislatures choose to combine the two acts, they have an important choice to make. Most elements of damages in these cases are independent. The decedent's pain and suffering is entirely separate and independent from the family member's loss of society and companionship. The one point where they do overlap are damages elements related to the decedent's income. Survival acts compensate earning capacity. Death acts compensate loss of financial support, which is a subset of earning capacity. So when legislatures like Michigan combine the two, they have to choose between those two mutually exclusive remedies. The first question for this court is, which did Michigan's legislature choose? The express reference to loss of financial support with no reference to earnings answers that question. It's an answer that was so well understood and accepted in Michigan that for decades, plaintiffs in wrongful death cases did not seek earning capacity damages. They only sought loss of support. When you apply the legislature's selected remedy of loss of financial support, the rest of the analysis in this case becomes simple. This court has already established how to show loss of financial support. And when you reestablish loss of support as the measure of damages, questions concerning speculation and how to establish the earning capacity of a deceased minor fall away. I welcome your questions. I was really banking on you having questions. I do want to, I'll comment on a couple things, see if I can maybe solicit some questions. One thing that I think is very important in the structure of the damages provision of the Act is how it's structured. It's a common structure. It starts with a very broad language, fair and equitable. And then it goes on to have a list. And that isn't unique to this statute. That's done in many statutes. And there's a principle, there's a Latin term for it, I'm not going to try to pronounce it, but it's where you have a broad category followed by a list of examples. That list has a limiting effect on the broad category. That's how you give meaning to all those words. Otherwise, the broad category subsumes the list and renders them surplusage. So in this case, the important point to take away from the list that follows is what it lists are 3 categories of damages. That is, Injuries the decedent suffered or damages the decedent incurred before death. That's medical expenses, loss of, or pain and suffering. Expenses the estate incurs after death, funeral, burial expenses. And then losses to the decedent's survivors, beneficiaries. That's loss of financial support and loss of sighting and companionship. Lost earning capacity damages, which are at issue in this case, don't fall into those three categories. And so by virtue of that, the legislature is showing how it has selected to compensate wrongful death damages in the structure of this act. Another important thing for the court to know.
Let me just jump in because you
Sure.
were asking for questions, and the one thing I've been thinking a little bit about, maybe you can help me with, is the lost earning capacity damages claim is a survival claim, right?
Yes, it's a traditional Survival Act type of claim.
So what do we make of our court's decision in Wesh versus Mecosta County Road Commission that says that a wrongful death action will no longer be regarded as one created at the time of death, but as one that survives by law? What impact does that have on your argument?
That's where it's essential to understand the fact that the act is a combined act. It definitely has Survival Act features. It definitely has Death Act features. So there's no dispute. I'm not disputing that this is a medical malpractice claim. The medical malpractice law applies to it.
Were we wrong in Wesh then?
No, I don't think West was wrong in how it described that concept, that aspect of the act. I do think it's incomplete because it doesn't contemplate that undisputably, I think, this act does go beyond just a Survival Act measure of damages. It expands into allowing damages for family members, beneficiaries, dependents, and the like. That is specifically and expressly a Death Act measure of damages, and it provides for those expressly. So what Michigan has is a combined act. It is both the decedent's claim and also a claim to expanding upon and including Death Act elements. The critical
I get the fact that it's combined, and we've recognized that, but in Wesh it seems to pick one over the other. Am I reading it incorrectly?
I think you are, to the extent that you're reading it to exclude the Death Act feature of the act, then yes, I think that's over-reading what Wesh was saying. That it is still there's a survival aspect to it. I don't think I need to fight with that aspect of this court's jurisprudence in terms of describing wrongful death act as providing both for the
Just to be more, I guess to be specific, you don't believe that the analysis and holding in Wesh impacts this court's holding in Baker?
No, I don't think anything in Wesh necessarily repudiates or overrules Baker itself. And in particular, I think the structure of the act as it has developed over the years, there are two significant amendments. I'm sure you're very familiar with them, 1971 and 1985. None of those amendments specifically repudiate what Baker said. And in particular, if you go back to look at estate of only, which preceded Baker, and described the act as providing for three categories of damages, that same structure continued throughout the act. There's a combined act. It's providing for remedies for the decedent's type of injuries and for the beneficiaries. It's providing for three categories of remedies. Back then, they used the term pecuniary damages. Now, the legislature has spelled that out in a little bit more detail because there was a lot of back and forth about pecuniary as a limiting function as it relates to non-economic damages. So that went out, and now the legislature has spelled out loss of financial support and loss of society and companionship. So I think the same three sort of category structure that you see referenced in only continues to exist in the act today. It specifically references funeral and burial costs. It specifically references the decedent's pain and suffering. And it specifically references losses to the beneficiaries or the family members and dependents. So that structure remains, and nothing in the development of the act from the time it was enacted as a combined act in 1939 through the amendments rejects the idea that Michigan has that combined act aspect, where you can still view it as the decedent's cause of action. One important point I do think to pay attention to as well as the entirety of the act, starting with subsection 1. it refers to an action for damages. It doesn't expressly say an action for the same damages or those damages. It isn't limiting in that fashion. So while it provides for the decedent's cause of action, or the decedent having a cause of action, it isn't limiting or specifically saying you get everything the decedent could have had. It says an action for damages, and then it has a damages provision further down. The damages are also, for the beneficiaries, the family members, are specifically addressed in subsection 3, which refers to those who suffer damages. So I do think that the structure of the act, while it has changed over time, retains essential features. As a combined act, expressly providing for traditional Survival Act type of damages, as well as specifically for Death Act damages. And those features have never gone away with all the amendments. So Baker's holding hasn't been specifically or directly rejected by the legislature at any point. So the one thing I did want to add to sort of the mischief that the Denny opinion creates. It isn't presented in this case, and the state hasn't argued it for it as well. But there are courts, and I do believe, I think the MDTC's brief pointed this out, there are courts reading Denny to say, well, earning capacity damages are now allowed. The statute allows for loss of financial support, so estates can get both, which is clearly a double recovery. And it's clearly improper under Michigan law. And the problem that Denny creates is that it is saying it's not giving recognition of the history of these type of acts, of the structure that's recognized throughout all the authorities involving wrongful death acts. And it's reading it in a vacuum to say, well, since the decedent could have gotten it, they can get it, and now lower court's saying, yeah, but the act also says loss of financial support, so we're going to allow both. There is no precedent supporting that. It has always been one or the other. There's no indication in this act that the legislature intended to allow both earning capacity and loss of financial support. So when I think you apply standard principles of interpretation to the act, when you look at the structure of the act and the various methods and frameworks that are out there in terms of how these are structured, there are 4, I lay them out in my brief, and you look at how Michigan has done it, it conveys that the legislature intended to retain that loss of financial support measure of damages in these cases. And once you return Michigan to that point, the questions related to how do we determine earning capacity for minors, those become moot. If there are no further questions, I guess I will reserve the remainder of my time for rebuttal.
Talk to me about Thorne.
Sure. Thorne.
Was Thorne incorrectly decided according to your theory?
No, I have no problems with Thorne. I don't.
Judge Talbot would be glad to hear that you said that.
Yeah, I'm sure he would. None of my argument is that the list following fair and equitable is exclusive. That's all you get. My argument is based on the statutory interpretation principle that list provides examples. And if you're going to allow something else, it has to be similar to those examples. In Thorne, they involve lost services that the dependents or beneficiaries of the decedent incurred after. That falls and is consistent with loss of financial support that they suffer and the loss of sight and companionship that they suffer. So I see no problem with that. It falls within the same category of damages, which is a traditional Death Act sort of compensation of damages. So no, I don't have any problems with Thorne. I think there's some dicta in there that goes a little too far in terms of saying, reaching into policy matters of why, well, if the decedent, had they been permanently incapacitated, they would have gotten the entirety of their income, and so it would be unfair in a Death Act for the estate to get less. One, that's a policy matter. It's a policy matter that legislatures address and deal with throughout the country. The majority of them have chosen the wrongful death measure of damages, a loss of financial support, to make those who survive the decedent whole. They don't see the purpose or the policy or the support the policy behind providing the entirety of the measure of damages to the deceased. Many have pointed out that there's a punitive aspect to doing that. So to the extent Thorne went into that area, I disagree with it, but the structure and the reasoning of Thorne, I don't disagree with, because I don't think you have to read that to be a limited list, although it has a limiting effect in terms of the categories of the types of damages that are recoverable. I will reserve the remainder of my time. Thank you.
Morning. May it please the court. Robert Kamenak. I'm here with my colleague Adam Wynn. We represent the plaintiff appellees. Let me start the argument off this way. In 1947, Michigan was the first English-speaking jurisdiction to outlaw the capital punishment altogether. And since then, this is a jurisdiction that has always valued life, even life of a convicted murderer. And that comes into play in this case because now, 177 years later, it is the consequence of the defense argument that it is cheaper to take a life than it is to merely injure, and that there is also some sort of special discount for the death of a child. And I bring those up not to be controversial, but quite frankly, those are the themes that have been gone back and forth with respect to various versions of the statute that was in effect, and also, more importantly, what I would call the give and take of this court in opinions going back over 100 years. And I think it's outlined in the brief perhaps to a fault, but you can see how much the Supreme Court in its prior opinions has grappled with this entire issue of whether or not there is a value to life and whether there's a financial consequence. We contend that there is. And when you look at the case law, I think, as Justice Viviano has already made clear in Weshy, but I think even earlier in Hawkins, the wrongful death statute and the survival statute combined really answer the question. Traditionally, across the country, there are 4 types of wrongful death statutes. And Michigan has opted in 1971 to have the type of statute that combines wrongful death and survival statutes. And when the legislature resolved the seemingly never-ending debate in this court between various justices in 1971, it decided that it was going to reach a policy decision, and it was going to be the jury that was going to decide what damages are fair and equitable under all the circumstances. That's the key language in the statute.
Counsel, could you address Brother Counsel's assertion about Denny and sort of the challenges that have come out of Denny that some courts are allowing for essential double damages? Do you agree with that?
I'm not familiar with courts that have allowed it, Your Honor, but I can see how it's a possibility. And I do think the way it works is the following, and I hope this answers your question. I think the jury can be presented with evidence of loss of earning capacity and loss of financial support if they exist in the same case. And the jury can decide which one is fair and equitable under the circumstances. But quite frankly, if you have a situation where the decedent was not financially supporting someone, what's fair and equitable is the lost earning capacity. That's the first answer, and I hope that makes the point. Also, logically, for the very same reason, you don't have those overlapping damages. So, for example, we have never intimated in a case that you can double up the compensation. It's not in our brief, and we don't contend that now. And we would hope the court would recognize that, and in any opinion, it would have that statement to be made. But the fact of the matter is, the jury chooses between the two. And the mere fact that both are available in certain circumstances does not, as the defendant claimed, mean that one is mutually exclusive of the other. It is in terms of the awarding the damages. It is not with respect to what the jury can choose. So we are not looking for a situation where there's double compensation or double recovery. Let me put it this way to summarize. Double recovery would not be fair and equitable under all the circumstances. And that's the language that our argument is based on. So I hope that answers the question, Your Honor.
Thank you.
So, two issues are presented to the court.
Just so I'm clear, that.
I'm sorry, Your Honor.
Just so I'm clear, is that the only limitation on categories of damages that the jury can award? They can award any type of damages sort of known to the law?
No. They can only award those damages that would accompany the underlying case. Let me give you an example, if I may.
I mean, could they award punitive damages?
Only if the underlying action had punitive damages, which in Michigan is very, very, very rare. So whatever the damages are in the underlying case that, as you pointed out, Your Honor, that survives and carries over and is not filtered out, under Weshy it's not filtered out at all. The character of the action is not filtered out, and the nature and the scope of the damages are not filtered out. So maybe another example would be the following. Let's assume hypothetically that you had a statutory conversion claim, which we all know are trouble damages. And again, I'm just trying to make the point. I'm not saying this is going to happen very often. Would those trouble damages carry over to the wrongful death case? Yes, because they're allowed in the underlying case. Punitive damages, if they're allowed in the underlying case, God bless, they carry over.
Was Baker wrongly decided when it was decided, according to your theory?
Well, Baker is irrelevant under our theory because it interpreted statutory language that no longer exists. Baker interpreted the language, which was the limitation on pecuniary damages and injuries.
Well, the fair and equitable language was there, was it not? Or
Right, but the fair and equitable language was there, but Baker did not address that at all. What it did is it really keyed its entire analysis on the pecuniary damage award and the limitation that was there. And quite frankly, since Baker, then you had the 1971 amendment of the statute that we're talking about the current one, but the 1971 is really the one that I think is where the legislature pivoted. And since then...
And how do we know that it pivoted? What words did it use that you think signify a major pivot?
Well, it got rid of the limitation, even though the case law had suggested this earlier, but it got rid of the limitation on the limitation to pecuniary damages. So, but since then, Baker's, I mean, we checked, Baker's hardly ever been cited. And Your Honor, even in your dissent in Langell and Toma, it wasn't so much that Baker would have an effect, it was this court's discussion that maybe there should be discussion of Baker, but not necessarily, and if I read your dissent correctly, not necessarily that Baker would have an effect on interpreting the current statute.
Well, it was a dissenting statement, I think, indicating that I thought we should grapple with these issues, which we're doing today. So it's, I'm either going to deserve the credit or the blame for that, I guess, depending on your perspective. But the question is, whether the court here, the Court of Appeals, could sidestep Baker, or whether Baker's still binding precedent. So I think we do have to grapple with these questions. And the question is, I think, more specifically, whether by adding the word including, I think that's one of the changes, and adding the phrase under all the circumstances, the legislature intended to abrogate our holding in Baker. Is that, or am I not stating the issue correctly?
You are stating the issue correctly, and on the including, I can address both points.
Please.
On the including,
why did they say including and not including but not limited to?
it doesn't need to, because including in the context of the statute and under even the Scalia rule of interpretation is inclusive, not exclusive. It's not
Always?
It is in this context when you have the broader category first, which is what's fair and equitable under all the circumstances, and then you have the including word, which is exemplary of the particular damages that are set forth. And why I say that is I think that, in my mind, Your Honor, that's the only way you can interpret the statute consistent with Hawkins and Weshy. So in Hawkins, and I'm going to quote it because I think it's important. I don't usually do this. Plaintiff's cause of action is without question one rooted in the survival aspect of the wrongful death case. The mere fact that our legislative scheme requires that suits for tortious conduct resulting in death be filtered through the Death Act does not change the character of the action except to expand the elements of damage. It's that expansion of the elements of damages that are in those categories. But there's nothing exclusive about it. And to rule that that would be exclusive, in my mind, would be inconsistent with Wesche, inconsistent with Hawkins, inconsistent with those cases that have adopted the Hawkins point of view, Hardy versus Maxheimer, all of which is in our brief. So we read the statutory scheme differently than, obviously, than the defendant. That's why we're here. Okay. And I do think the Court of Appeals was correct in terms of, I think we've given the court more ammunition, so to speak, about why including is exemplary, but I do think the Court of Appeals was correct in the way it analyzed it.
Mr. Cameron, can you, I want to turn your attention to the second
Sure.
issue, and I'm wondering, it's an issue that causes me great concern about, how to determine the future earning capacities of a 13-year-old or a newborn, whatever it may be. And the concern I have is if that is permissible and left to a jury, and some of the things for them to consider are things like demographic and, demographic information, educational opportunities and that. And the concern I have is, are we going to end up with a result where children of certain demographic characteristics are going to be compensated, or parents or whoever, be compensated more for those children? Say a white male from a, really affluent school district has the potential to earn more than, somebody not with those characteristics, and opening the door for, even if we can get past speculation, isn't it it's subject to inherent bias about some real concerns about that being the test for determining earning capacity for a child?
Is it possible? Yes. Is it likely? No. I think the whole notion of averages, which are statistics, and God knows I did poorly in statistics at the University of Michigan, but statistics, by their very nature, take averages over a huge subset of persons. I would hope that when an economist comes in, such as Dr. Paranjapi here, wouldn't necessarily limit those averages to any particular group, any sociology group. And instead, perhaps the better way to go about it is to look at whether, to some extent, whether people tend to go to college, tend to have a job, tend to get employment consistent with a bachelor's degree, other factors like that, and of course, escalation factors.
But aren't those things all inherently bound up in things such as poverty, educational opportunities, whether their parents have gone to school? There are some real systemic concerns about, and so even if you're saying I'm not going to specifically look at demographics, I'm going to look at, what is the percentage of 13-year-olds that go on to bachelor's degrees? It can be a big difference, right, depending upon opportunities available to certain 13-year-olds.
It is, but I would suggest, Your Honor, that the alternative is worse. And the alternative is that what we have to some extent in the Court of Appeals opinion in our case, which wasn't really much of a ruling because, as you know, the Court of Appeals in our case said it, for a 13-year-old, it was not inherently speculative and remanded back. You have Zahil. I know you're holding it. It's a different fact situation, and I don't represent anybody in Zahil, so I want to make that clear. But at the end of the day, one thing that we've been arguing, and I wanted to impart to the court, is I think it would be speculative for any ruling that a child, regardless of age, but we'll take the 13-year-old here, would not at least get a high school education and not get a high school diploma equivalency job. The greater harm is the lack of compensation than the overcompensation that the defendant's arguing, or some of the concerns that you have brought up. And I understand the concerns. I think that at the end of the day, all the parties have the opportunity to cross-examine the economist. I don't think you can come into court and just give statistics. I think you have to have an expert who does it, and I think it's all subject to cross-examination. I'm not, I'm assuming the court's not going to look at some sort of rule that would limit that. I think that we'd have to see how that develops, and if that happens, then a court rule could always be enacted, as court rules have been enacted otherwise, to prevent those type of considerations.
Well, those are considerations and concerns that are inherently hard to ferret out, right? I mean, that's what inherent bias is. And that's my concern, right? I mean, I know that we can have statistics, but they're based on assumptions, and they're, you know, sort of undoing it and saying, well, we can correct that on the other end is a concern of whether or not that gets over or under corrected, either way.
Correct, and all I'm suggesting, Your Honor, is I'm not denigrating your concern, and I'm
No.
not saying that it's not a concern. But I do think we have to see how it plays out in cases. Because at the end, you know, when an economist walks in and you've got our, God knows how big, 500-page appendix with all the material that Dr. Pranjapi looked at, you know, you'd have to dig behind that to see what was going on. Federal Social Security Trustees Report, Michigan minimum wage growth. Yeah, there may be some inherent bias in that. I do not know. I do not know, because that was not done in this case. Because as you know, Dr. Pranjapi's affidavit was submitted, it wasn't rebutted, and his report wasn't rebutted at all. That's the state of the record in this case. We didn't have the record developed where we could get to the very concerns that you raised, Your Honor. So since we're on that topic, I think to be clear with respect to the second issue, what degree of specificity is needed, there's nothing unusual about the Wrongful Death Act. There's no special provision. As I talked about earlier, the underlying case carries over. So whatever the damages would be and whatever the degree of a reasonable basis to figure out the amount, it would govern. So the case law from this court is clear. You can have speculation on the existence of damages, but not necessarily on the amount. The court just looks to see whether or not there's evidence that from which a jury has a reasonable basis to decide the amount. And that case law goes all the way back, and it's very consistent. There's nothing that interrupts that. And obviously in a case like this, a death case, the existence of the damage is a given, because the decedent's not going to work. So you get over the first hurdle. The only hurdle that has a speculative element doesn't even exist in these type of cases. And then it goes down to the amount. And if there's a reasonable basis, then the jury can decide it. And if you have reliable statistical averages, it can be done. We disagree with the Court of Appeals opinion to the extent that it says you have to have personal characteristics of the decedent. We think it helps, and we think that it would be additionally persuasive to a jury in certain circumstances. But I don't think, and our view is that you don't need them. And we have cited in the brief, I think, the Restatement of Torts Remedies, section symbol 18. And they talk about there's two different approaches in the country, one of which is to look at personal characteristics, the other of which is to look at statistical averages. But at the very end of that, they say, and I quote, either approach that I just described is more accurate than assuming that a child would have zero lifetime earning capacity. Assuming zero lifetime earning capacity is grossly undercompensatory. That's straight out of the restatement, and I think it hits home. What we've been arguing, just to give the court, I know there's been questions about what's going on out there. A couple things going on out there. What we've been arguing in courts, oftentimes with Dr. Pranjapi or somebody of his ilk, is that really, in this day and age, the backstop, so to speak, for loss of earning capacity is that you're going to get a employment at least consistent with a high school diploma. And I don't think there's anything speculative about that at all. Nowadays, I said it earlier, but I think it would be speculative to assume that somebody wasn't going to get at least a high school equivalency job. The other thing that comes to mind, and I'm going to go back to Denny, questions were asked about Denny. The financial sky has not fallen since Denny was released in 2016. We don't have that going on here. And absent questions, let me pivot, if you would, to a couple points with the amicus briefs. I usually don't address the amicus briefs, but here it looks like the healthcare industrial complex has come after us. So A couple things. The financial reality of what's going on, both in Michigan and across the country, is that you've got these massive consolidations going on of healthcare systems. And the whole notion of that is with size, with integration and the like, they can cost control much better. This is not a situation where there's a huge risk of runaway verdicts. Footnotes 4 and 5 of our brief talk about nuclear verdicts and where they're occurring. And one of the amicus briefs gets into that if you allow this element of damage, if this category of damage is allowed, you're going to be playing into nuclear verdicts. And you're simply not. We've given you the statistics. Michigan's not a nuclear verdict state. Your Honor, may I finish my sentence or two? And then I'll sit down. And the other thing that I want to impart to the court that it's been in all the newspapers, and I think it's common knowledge. In Michigan, in particular, you've got healthcare systems that are buying up hospitals left and right. You've got mergers left and right. You have many of the amici that filed briefs here. They're making, I'm not denigrating them for being both nonprofit and capitalistic, because they're both, but they're making massive amounts of money, and their revenues are in the billions. Last time I checked, we have 3 healthcare systems in Michigan where their revenues in 2002 or 2022 or 2023 were around $40 billion. That's just 3 entities. So it's not as if recognizing this category of damages is going to bankrupt Michigan or any healthcare provider. So I'd ask the court to affirm, and if I can answer any other questions, I'll try.
Thank you very much.
Thank you.
I want to start with comments on Baker. Mr. Kamenek argued that Baker focused on pecuniary injury language of the statute. The Court of Appeals in Setterington got this absolutely correct when it described the current statute as having the clearer expression of the same item of damages, where it now refers to loss of financial support and loss of society companionship. The pecuniary injury component is the same as those. The legislature has carried over and expressly provided in clearer terms, because there was a lot of back and forth in this court about loss of society and companionship, to spell out exactly what that pecuniary injury is. Another point I want to address is the concept that the juries get to choose, that this is just a policy debate to be held in front of the juries. There is no support for that, either in the statute or any precedent for it in any other state in this country, where you just go to the jury and say, you guys choose about what makes sense from a policy perspective of earning capacity or lost financial support. Where suddenly the juries would be subjected to expert testimony on the cost of the healthcare system that you'd see in front of you in the amicus briefing. These policy issues are for the legislature. The legislature made a choice. It expressly stated loss of financial support in the act. It couldn't have been clearer about that. There's no reference to earnings. If it were different, if it were earnings or loss of financial support, that argument would have some weight. But it isn't. There's only one. Another point that I want to address is related to the concept of Michigan value in life. Wrongful death acts are difficult policy choices. It isn't a matter of not valuing life. The legislature in our act expanded who can recover damages well beyond what can be recovered in a traditional tort injury short of death. There's a balancing that has been done here in the act. Also, as guidance, in addition to the fact that the majority of the jurisdictions in the U.S. compensate lost financial support, not earning capacity, Michigan's No-Fault Act is an extremely detailed statute that covers a large number of injuries in the state of Michigan, specific to no fault. And in that act, it provides for survivors' losses, survivors' benefits. So there you're showing, the legislature showing a selection in that complete compensatory scheme of how it's choosing to compensate in a death scenario. So I don't think it's just a matter to be punted or given to the jury. It's not we don't value life. It's a legislative policy decision weighing a lot of factors in terms of who's bearing expense and what the public policy of the state is going to be in terms of things like what the amicus bring up, allowing hospitals to have maternal fetal medicine practices, inherently high-risk practices, allowing hospitals to reach out into the communities and provide for facilities in rural areas, areas that are underserved. These are all tied up in the decisions and choices the legislature is making, and it's not absurd, it's not unfair, it's not harsh. It's a balancing of policy. It's reflected in the statute in terms of how it lays out the damages that can be recovered, which are, again, beyond what can be recovered, even in the most harmful, permanently incapacitating type of personal injury case. The Death Act still, or Wrongful Death Act still goes further than that. So it's a carefully struck balance. Denny upsets that balance. So we're asking you to overrule Denny, reverse lower courts, and return Michigan to a loss of financial support jurisdiction. Thank you.
Thank you both. The case will be submitted.